We are ready, counsel, to begin.
Morning, Your Honors. May it please the Court, Benjamin Waxman, together with Michelle Borton and Paul Palacios, who just left, on behalf of the appellant, Nellie Yanes. I'd like to reserve 4 minutes for rebuttal, please.
Thank you.
This is on appeal from a summary denial of a motion for post-conviction relief based on ineffective assistance of counsel. In this posture, the Court must accept that Yanes, who lived in the United States for at least 10 years and has 3 United States citizen children, received ineffective counsel when her attorney failed to advise her of the clear and inevitable deportation consequence of her plea in criminal court. This Court also has to accept as true that had she received proper advice on this matter, she would have rejected the plea and she would have insisted on her right to trial. So the only issue before this Court is whether Yanes was entitled to an evidentiary hearing, which we believe she was.
And just one clarification. I know she indicated that her attorney failed to advise her. Did she acknowledge, what did the Court do? Because typically the Court's colloquy usually includes a sentence about deportation. What is her assertion as to what the judge informed her while she was taking
Well, the plea colloquy is not in the record.
That's what,
But the standard colloquy from Rule 3.172C8 is merely that the plea may result in deportation. And that's the whole issue that came up in Hernandez in the Florida Supreme Court, where the Court recognized that that may warning from the Court is not adequate to supplant or to eliminate prejudice where the attorney fails to satisfy the attorney's obligation under Padilla to warn that deportation is certain to occur.
And we don't know here whether the Court, because again it's not in the record, whether the Court used the word may or the word shall in compliance with Padilla.
The assertion in the motion is that she was never warned that she would be deported as a result of this plea, and that's not part of a court's normal obligation and normal practice under Rule 3.172C8. The easiest way to resolve this case is through the binding precedent of this Court's decision in Rodriguez, which, upon very similar Rule 3 allegations, held that it was sufficient and required an evidentiary hearing once the defendant asserted that had the defendant known about the certain deportation, they would have rejected the plea and proceeded to trial and insisted on their right to trial. And that's the simplest way to resolve this case.
Can I have you address the prejudice aspect of it? That if she acknowledges that she was not here legally, that she could be subject to deportation at any time, what difference would it have made?
Well, the difference that it would have made is that the plea that was entered, she had any number of different types of relief that were available through immigration court. She was eligible for cancellation of removal under 8 U.S.C. section 1229B subsection B. What happened in this case, and what she didn't know, is that by entering this plea without being advised that she made herself ineligible, she was absolutely and with certainty going to be deported under 8 U.S.C. 1182 A2A small I Roman numeral 1. This made it certain that she would be deported, and it also rendered her completely ineligible for cancellation of removal, which is a remedy among potential other remedies that she otherwise would have been able to avail herself of. And that's the reason why the prejudice test that the court in Cano has adopted restricts impermissibly the Sixth Amendment right to counsel, because the Sixth Amendment right to counsel doesn't provide for, in criminal proceedings, it provides that any accused shall receive the assistance of counsel. Ms. Yanes was an accused, And if she was entitled to the assistance of counsel as she was, then she was entitled to the assistance of effective counsel. And Padilla tells us that effective counsel is counsel that will warn the defendant of the clear and certain deportation consequences of the plea. And we know this also because in the due process context, under Plea, it says very, very clearly that all persons are protected and guaranteed due process, which is how the Sixth Amendment is enforced against the states. And it says specifically, even aliens whose presence in this country is unlawful. And it means what it says, and that's precisely what Padilla says when it said, without limitation, it said that no criminal defendant, whether a citizen or not, shall be left to the mercies of incompetent counsel. And what are we talking about when we're talking about incompetent counsel? Padilla tells us we're talking about counsel who has failed to warn his or her client of the clear and certain deportation consequences of the plea. And that's precisely what advice Ms. Yanes was denied here. The very advice that she needed in order to make a knowing and intelligent and a voluntary decision about whether to forfeit all of her rights in pleading guilty.
How do you respond to the argument that in Padilla the court went out of its way to emphasize that Mr. Padilla was in the United States lawfully? He'd been here for 40-some years. He had, I think it was 3 children that were United States citizens.
I go right to the holding, Your Honor. And the holding on page 374 says, it is our responsibility under the Constitution to ensure that no criminal defendant, whether a citizen or not, is left to the mercies of incompetent counsel. And that's consistent with, again, Plea, which says that due process is guaranteed not just to citizens, not just to lawful residents, but anyone who is present, even aliens who are here unlawfully. And this is the nature of our constitutional rights. Basically, for the court to adopt Cano, we're basically saying that if you are not here unlawfully, you don't even need to have an attorney by your side at the plea. In fact, let's do away with the colloquy that a judge gives a defendant, because who really cares? This person is here unlawfully or is otherwise deportable. So they're not entitled to counsel. They're not entitled to effective counsel. We don't care, but that's not what the Sixth Amendment says. The very text of the Sixth Amendment, which says that an accused, there's no limitation there. Plea says that due process applies to anyone who is present, even aliens who are here unlawfully. And then again, if we go to the very language that was used in Padilla, it's clear and there's no limitation. It talks about the no criminal defendant can be denied this right.
Would you agree that under Strickland, Padilla is a prong 1 case, that is deficient performance?
No, I think I would agree with that. It is.
So with regard to the status of whether you are a legal immigrant or an illegal immigrant, would that be properly placed under the second prong, whether or not there's actual prejudice in terms of analysis?
Correct. And the prejudice under Hill, which is the measure of prejudice in the plea context, asks the question, would the person, had they been given the correct advice, would they have rejected the plea and insisted on their right to trial? And the way these cases arise is that a defendant, in making a prima facie case, makes that assertion that had I been told, I would never have taken this plea and I would have insisted on my right to trial. And then what happens is the trial court grants an evidentiary hearing because the defendant has made out a prima facie case for ineffective counsel, and at the evidentiary hearing, that's when the court considers all of the particulars of the individual situation to make that determination. Would that person really have rejected the plea and have insisted on the right to trial?
To the extent then that Cano can be read to say that the status of your immigration status, that is an illegal immigrant, falls under prong one, Cano, your contention, is improper as a matter of constitutional law.
That's correct.
But it would be appropriate when under prong two to determine prejudice. In most instances, since you can be deported for being illegal, most generally speaking, I hate to use strong because we're going outside our record, probably are going to have difficulty with the prejudice prong. But your complaint, as I understand it, suggests that there's a curative aspect based on her years of residency and the fact she has children. Is that correct? So that's a subset of the other ones, which may move towards a necessity for an evidentiary hearing to find out if there is, in fact, in her situation, prejudice.
That's exactly correct. And to, again, this court cannot restrict the rights that are established by the United States Supreme Court. And clearly, under Plea, we know that Ms. Yanes was entitled to the same advice, to the same rights, and to the same counsel as a citizen or anyone else. Cano does another thing, which is interesting, is we have a case called Grosvenor, which I cited, which talks about the test for ineffective assistance of counsel, and what it says is that in determining prejudice, the court is to consider the totality of the circumstances. So, Judge Casanova, what I understand, there's no, did I mispronounce it?
Well, you have made my mother happy since she's Italian descent. You took out the U, you put an O. So you made at least one side of my family happy. My father might have pronounced it differently, Casanova being Spanish.
I apologize.
It's all right, not to worry. It's not like I haven't heard it before.
The point I was trying to make is it's not entirely clear from Cano, which sets out these 6 prerequisites that come out of nowhere, because we've been evaluating ineffective counsel under a 2-pronged test that's come from Strickland, it's come from Hill, it's come from Grosvenor, and all of a sudden Cano comes up with these 6 requirements. But the 2, I think, go to the issue of prejudice. I think that's the question of, and the 2 requirements are that a defendant show and be able to plead that they were lawfully present at the time of the plea, and that there be no other basis for deportation. Those really go to the question of prejudice, because basically the court's saying you have no standing to challenge the plea in this case if you had some other, if you weren't here lawfully, or if you had some other basis for deportation. But Grosvenor very clearly says we need to consider the totality of the circumstances, and that's the job of a court, of a trial level court, in granting an evidentiary hearing. And Rodriguez and other cases that have followed it, including O'Neill, have said that once the defendant makes the showing, they say that they did not receive the clear and certain, the clear advice about the certain consequence of deportation, and they allege that had they had that advice, they never would have entered this plea and would have insisted on trial. That person has made out the prima facie case. And Cano, again, it essentially signals the end for all criminal procedural rights for someone who is not a citizen and someone who is not a lawful resident. And that is something that is so foreign to our body of constitutional rights, and again was explicitly stated in Plea. And no other court particularly has adopted the standard in Cano. I mean, the 4th DCA, recall, is the court that brought us Flores. Flores was the case that was overruled in the Florida Supreme Court because Flores said that the trial court's warning is sufficient to supplant the obligation of counsel to advise correctly about the deportation consequence. And in this case, the court again has it wrong. It never cites to Hill, the landmark U.S. Supreme Court case that gives us the test for prejudice, that tells us what it is. It never cites to Grosvenor, which tells us, no, there's not a quick and easy checklist of issues that if you can't allege or you don't allege, knocks you out of the box. They never cite to that case. And the only cases they do cite to are other 4th DCA cases that kind of incorporated this element of that you need to show that this is the sole basis of deportation. Cases like Forrest and I can't think of the other case right now, but Rosas, also out of the 4th DCA, both of which were pre-Padilla cases, so they did not arise after Padilla, and both of which arose outside the Sixth Amendment right to counsel context.
You are at 16.
I'm sorry?
You're at 16. You're at your 4-minute mark. That's
Thank
the warning
you.
you asked for.
If it please the court, good morning. My name is Patricia McCarthy on behalf of the state. Yanez's theory is that the plea was the sole basis for deportation. Lest there be any doubt that that's the claim that she brought before the trial court, in her 3850 motion, she persisted in the refiled motion in stating that the plea was the sole basis for her removal proceedings, volume 1, record page 12. That's patently wrong. She's removable because she's an illegal alien. Now, what she did was, in the refiled motion, is add a memorandum that talked about, well, had it not been for a plea that she claims rendered her presumptively deportable, that she could have applied for a discretionary act by the Attorney General, the U.S. Attorney General, of discretionary relief from removal. So what she does is, she asks the court to find essentially that there's only one basis for removal, because she can't apply for cancellation. But what she's doing is she's ignoring that there is an independent, freestanding basis for removal here. Now, what she's suggesting to the court is that counsel, in essence, now she doesn't state that clearly in her 3850, but it's in essence at the core what she's asking the court to find. That Mr. Ojeda, in 2011, had a constitutional obligation to be reasonably effective to tell her that the plea could affect other grounds for removal. Now, she doesn't allege that in the 3850, but that's really essentially what she's asking the court to find here on appeal. Now, there's nothing in Padilla that requires any such finding. As Your Honor has pointed out, Padilla is a first-pronged case, and it dealt with what was before the Padilla court was a lawful permanent resident. So they never had to reach whether the fact that counsel had to advise as to discretionary relief for other grounds for removal. That was the sole basis for removal in Padilla's case, his plea. And that isn't what is before the court here today. So what
There's at least one or two law review articles, one by Mr. Hernandez in the, I think it's Rutgers Law Review, that suggests that Padilla does not apply to non-legal immigrants, and apparently it's been cited by, I guess, the college they call themselves with approval in other law review articles.
Well, we have submitted in our brief that Padilla doesn't apply in the case of an illegal alien.
Well, let me play advocate with you on the other side for a moment. As I read Padilla, and I start off with a notion from the Sixth Amendment, it says an accused, which arguably the appellant here would be an accused. As I read Padilla, page 364 of the opinion, talk about a non-citizen's criminal conviction, non-citizen defendants who plead guilty, and as would appear to be a non-citizen. On page 366, they cite sincere with approval, talking about an alien defendant, and as would appear to be an alien defendant. We can go through other pages, 371, 372, 374, where they use broad terms like clients. My concern is, as I attempt to interpret what the Supreme Court of the United States has said, I don't find a limiting adjective or adverb in front of non-criminal defendant that says legally, illegally here. They use the broader term rather than narrowing. Is that a correct way to read it in your view?
Respectfully, no, Your Honor. And that is because Padilla is limited by the facts of the case. It didn't decide whether an illegal alien is entitled to, or counsel for an illegal alien must advise him as to the impact of a plea on other grounds for relief. And I would point to the court's reference to St. Cyr in Padilla.
Yes.
Yeah, I may have mispronounced that, I apologize. That was a habeas case challenging a removal order. And they found he was ineligible to apply for cancellation or removal. It wasn't a Sixth Amendment case. And also, in Padilla, the court points to the fact of the importance of what a non-citizen might want to take the risk of taking prison in hopes of being able to avoid removal, okay, taking that risk, but it talks about the right to remain in the country. She had no right to remain, and that is specifically in the Padilla opinion. So we would submit by the very facts of Padilla, it didn't reach this. And what does that mean for counsel? Mr. Ojeda, who represented Ms. Yanes in 2011, the counsel didn't have before the U.S. Supreme Court case telling him he had to counsel this client as to the impact of the plea on other bases for removal. Now, the court has asked, does the plea colloquy, what does it say? And the court has regularly resisted the state's attempt to add things to the record that on appeal in a summary proceeding, but we can glean from her own allegations what the court said, that he states at record page 14, the court did warn her through an interpreter that if she's not a U.S. citizen, the plea could result in deportation. Now, this isn't a case about the adequacy of the trial court's advice. We know that. This comes to us in the context of a Sixth Amendment claim of ineffective assistance. But that said, how could counsel rightfully tell her that the plea would subject her to deportation? All that INS official has to do is say, you're deportable because you never arrived here from Honduras through Arizona lawfully. You never came here lawfully, you never had any lawful status, you didn't have a visa, you didn't apply for relief, you had no lawful status here that even expired.
Would that be a second prong of Strickland versus Washington, or a first prong of Strickland versus Washington? Because if it's a second prong, arguably, there's a prima facie, this is a summary dismissal. If this is a first prong, and it's a question about whether or not Padilla's advice applies, that's a legal determination. If it's illegal status, if that's under the second prong, prejudice, won't that require an evidentiary hearing to determine what all the immigration laws were, what the likelihood of success is on the appeal for the immigration, because I have been in the country for 10 years and have 3 children. I mean, I think it's important where this fact is laid. If it's part of the first prong, part of deficient performance, in order to have deficient performance, you must be a legal alien. Then that would resolve that as a matter of constitutional law. If it's a matter of the second prong, seems to me then the argument would be that she has stated a facially sufficient claim under Padilla, and the argument would be, let's have the evidentiary hearing and find out if there's been in fact any prejudice. Would it be reasonable to her to go to trial? What are her chances of success? And the trial court may still find you have not been prejudiced in this case.
My answer, the state's answer to this is that it's applicable to both prongs. And they're inseparable. That issue is inseparable with respect to both prongs. On the performance prong, she would have to show the counsel that it was a deficient performance on its face not to talk about the plea's impact on other grounds for relief. And let's look at the landscape of what the cases she cites. She cites Padilla. Padilla was decided the year before, in March of 2010, but as the state's pointed out, it didn't address what was constitutionally effective advice. In fact, Padilla was a case about misadvice. that counsel, I believe, had said something to the effect that you don't need to worry, you've been in the country so long. Okay, so, and Padilla doesn't cite any case, and we know that Padilla created a new rule because Chavez tells us that. And the U.S. Supreme Court decided it wasn't retroactive. So what, in essence, Ms. Yanes is asking this panel to decide is that counsel had an obligation to do something that the U.S. Supreme Court never has held counsel to a criminal defense attorney to give advice on regarding the inner workings of a removal proceeding regarding other grounds for relief. So we'd say for the order here was on the prejudice prong, it's right for any reason.
So you would have us focus on that part of Padilla that talks about there's two forms. When it's clear there's going to be a deportation,
Right.
it's failure. But if it's
Right.
not, they've talked about where it's not unclear,
Right.
the counsel doesn't
That's
necessarily have to do anything to,
That's correct.
that wouldn't impact.
And it isn't clear here. And why isn't it clear? Yanes's position is, and she's very capably promoted this position, that it is clear because she's presumptively deportable. Well, we have not, we've assumed for purposes of a summary review, her allegation this is true, that it's a crime of moral turpitude. We haven't conceded as a matter of fact. But assuming arguendo that, still, she is an illegal alien, and she can't show that Mr. Ojeda had that constitutional obligation to inform her about the discretionary acts within a removal administrative proceeding. So yes, it's not clear. Also, it's not clear that she would be deportable based on the plea. Why isn't it clear? Because there's an independent basis for removal. So all that INS officer has to do is to say, I'm sorry, Ms. Yanes, you've been here unlawfully this whole time. Even if you didn't commit this crime, we're deporting you. And so that's why counsel can never be deemed deficient in the case of an illegal alien as a matter of law. Now, the state is submitting that it's also correct to conclude that you can't establish prejudice. Now, the court has indicated, well, why don't we, that if it does only apply to prejudice, then we must have a hearing. But the 11th Circuit in Gutierrez this year, in April, didn't find that. They were faced with very similar circumstances, and there was a summary, there was a magistrate's judge's recommendation of denial of a 2255 motion to vacate on an ineffective claim involving an illegal alien. No evidentiary hearing. District court denies relief. The 11th Circuit concludes that she cannot rationally show she would not have rejected a plea, and they didn't need a hearing to show that because she was removable for an independent basis. Now, granted, the 11th Circuit doesn't say Padilla doesn't apply to illegal aliens, but however the court wants to form its opinion or conclude, the right result is reached by the post-conviction court here. Because even if she says over and over again to the post-conviction court at an evidentiary hearing, I really, really, really would have liked to have had the chance to apply for cancellation or removal, the fact remains that whether she's convicted or not, she's deportable automatically as a result of her illegal status. So I know that Ms. Yanes has tried to say the sole basis, and she clearly affirmatively says that this is the sole basis for her removal, but that is patently wrong. It is not. And so whether the court decides to affirm on the prejudice prong or the performance prong, either outcome is appropriate, that she's not entitled to a hearing just as in, because she can never, as a matter of law and logic, establish actual prejudice from the plea, because she was already here at the time of her plea unlawfully. Now, I would like to address before I conclude, I don't know how much time I have left.
7.5 minutes.
Okay, counsel has pointed out that she has a due process rights. The due process cases she refers to are not Sixth Amendment cases. They're not cases from the U.S. Supreme Court saying that a state court is required to grant an evidentiary hearing in a state post-conviction proceeding. I know of no case holding that. And the cases she cites do not certainly hold that. So you're not going to run afoul of Padilla or Strickland in concluding based on her allegation she's not entitled to relief under the prejudice prong. In other words, merely because she makes a conclusory, bare-bones allegation, I would have taken the chances of applying for cancellation, which, by the way, she doesn't allege specifically in her 3850. But even if that were enough, that allegation, not enough, but even if she had made the allegation, she could never establish actual prejudice because she comes hindered to the post-conviction court in the first instance because there's an independent basis for removal. But I'd ask the court to hold that Mr. Ojeda had no obligation to talk to her about the plea in relation to other grounds for removal. To do so, to hold, would be to extend Padilla beyond its holding. And there's no, I know that he has cited, opposing counsel has cited Supreme Court precedent regarding the adequacy of a plea colloquy. Those don't drive that result. She is deportable aside from her plea. That is the problem that hinders her grant for relief. It's not that the state court is depriving her of a federal due process right. And by the way, she did not allege in her 3850 she had a due process right, so it would not seem appropriate that for the court to even entertain it, which also looks like it was raised for the first time in her reply. But even all that aside, on the merits, she doesn't have a federal due process right to an evidentiary hearing when the allegations, even as alleged, do not warrant a basis for relief. So we'd ask the court to hold, in the first instance, she can't establish the first prong pursuant to Padilla. The consequence is not clear because she, even with the plea, she's deportable for another reason. And she can't conflate the two reasons for deportation. She doesn't attach a removal notice, but she admits that she's being subjected to a notice of a removal that says, you came here unlawfully, you're deportable because of that. And that is a separate allegation from the claim that the plea renders her deportable. Had counsel told her the plea would render her subject to deportation, the state would submit, that could be seen as incorrect advice because it might not be the plea at all. It just might be that independent basis for removal. So how can we find Mr. Ojeda ineffective? We can't, based on Padilla or Strickland or Hill. And none of these cases require this court to hear this case below or require the post-conviction court to hear a claim that someone has a subjective hope of cancellation of removal from grounds for relief that provide an independent basis for her removal. And we'd ask the court to affirm the post-convictions order denying relief. Thank you.
Thank you.
Let me just make clear that Padilla was in full effect at the time that Ms. Yanes entered her plea, and counsel was bound by the obligations there. Let me make clear that the advice that was not given does not concern any additional basis on which she may have been deportable. It has to do with the very plea that she entered on that day in front of the court. Because what the immigration statute tells us right on its face, 8 U.S.C. 1182 A2A small I, Roman numeral 1, says that if a non-resident pleads to, is convicted of a crime involving moral turpitude, that person is removable. Then you look to the other thing that was not advised is cancellation of removal. Section 1229B, subsection B, on the face of the statute says that if a non-resident is convicted of a crime involving moral turpitude, they are not eligible for cancellation of removal relief. That's the advice that she was entitled to as she stood in front of the court and made hopefully a decision to forfeit all of her rights. The question about the applicability of due process. I didn't cite a case for this. To the best of my knowledge, the Sixth Amendment is only applicable to the states as a result of the 14th Amendment due process clause. That's what renders the other Bill of Rights enforceable against the states. So that's the very provision that Plyler talked about when it said we don't deny these constitutional rights even to aliens who are not lawfully present in front of us. That is a completely foreign notion to constitutional law and to the U.S. Supreme Court's interpretation of due process.
Let me make sure that I understood your argument. You're taking the position that as part of the right to effective assistance of counsel, that counsel, and you made reference to the immigration provision, typically in most criminal cases, the defense attorney would talk with their client, whether to advise them as to the deport, but then to refer them to either an immigration lawyer or somebody else for them to pursue it. I'm concerned with the fact that you're suggesting that this counsel should have been aware of the immigration subsection as to the cancellation or removal or anything like that. I don't know if I heard you wrong, but I wanted you to clarify that for me.
No, you heard me right, Your Honor. Padilla does impose this obligation on criminal defense attorneys to give advice to their clients who are going to be impacted by the immigration laws. And it does so when those ramifications and consequences are clear from the immigration statutes, and the result, the bad consequence, is inevitable. And that's precisely the situation that we had here. It is no longer sufficient for the criminal defense lawyer to say, you need to go talk to an immigration lawyer. That may be something that's good to fine-tune what rights may be affected, but as concerns the case in front of the court at the time of the plea, that's precisely what Padilla says. It says that defense attorneys have to be sufficiently familiar with the clear provisions of the immigration law to at least advise them of the inevitable consequences. And what we did is I cited numerous cases from out of state that recognize precisely the scenario we have here. The most devastating consequence for defendants that come in front of a court may well be the deportation consequences, the separation from family, the separation from property, and those may be the concerns that that person needs to weigh most heavily in making that decision. And that's why even if a person has a substantial risk of conviction at trial, and maybe they're looking at a substantial prison term in the trial, the courts recognize that for an immigrant, they may be willing to entertain that risk so as not to be deported, and they may well risk the longer sentence and a certain sentence over taking a much more modest sentence that will, with certainty, result in deportation. And
Thank
that's
you.
precisely...
I need to tell you time has long since expired.
Thank you, Your Honor.
Thank you. I just want to give you a chance to